This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Welcome to Discussions at the Roundtable. I'm your host, Noah Ballmer, and today I'm excited to speak with Steve Embry. Mr. Embry is an attorney, blogger, and chair-elect of the ABA Law Practice Division. As an attorney, he has practiced for over 30 years, focusing on mass tort, data breach, privacy, and cyber insurance. His blog, TechLaw Crossroads, examines the intersection between technology and the legal profession. Mr. Embry holds a JD from the University of Kentucky. Thank you so much for joining me here today at the Roundtable.
It's my pleasure to be here. I'm looking forward to it.
Great. Let's jump into it. Your legal career spans over 3 decades. You've seen firsthand the impact that technology has had on the profession. How did this intersection become kind of your focus? Was it gradual or did it kind of hit you at once?
It was gradual in a sense. I sort of remember having an epiphany many years ago. I was going on vacation with my wife and 2 children, and we were driving in the car, and my wife was driving, and I was working on a brief furiously, trying to figure out how I was going to get the brief done, since I was going to be on vacation and not in the office. And my wife said, take a break. And so I took a break, and I was reading this article in the American Lawyer about a lawyer named Fred Bartlett, who went on to found the firm Bartlett and Beck. Mm-hmm. And he was quoted as saying, I'm sitting in my condo overlooking the Rocky Mountains working on a brief that's due tomorrow back in my Chicago office. And I said, I think that guy's onto something.
Oh, wow. No, that's pretty good. Along with that, you do, again, 30 years of experience. When did you first, if you can even remember, start working with expert witnesses? When did that become a part of your practice?
Well, it wasn't very long into my career in practice that I began doing mass tort work on the defense side. And the very nature of those cases meant you had to have experts that could help you tell the story to the jury. Or the mediator for that matter, but always thinking of the jury. And so, it became clear to me that having experts and good experts was really pretty critical to your success in the courtroom and elsewhere. And so that's throughout my career, I've worked with experts of all sorts, from data scientists to engineers to doctors to you name it. So I've worked in tandem with them in just almost every case that I had.
Sure. Has that vetting process changed a lot over the years, over the decades?
Well, we certainly do more of it via Zoom now than we used to. But the fundamentals of it, at least for me, haven't changed that much. First of all, an expert has to have substantive knowledge in the field. Those are table stakes always. But beyond that, I'm looking for an expert that can communicate his or her ideas clearly, concisely, in a way that I, at first blush, can understand. Sure. And be an ordinary layperson can understand. And there's an old saying that and I think about this a lot when we talk about vetting experts. If I talk to an expert and the expert can't explain something to me in a way that I can understand it, either he or she doesn't know what they're talking about, or they're trying to hide something, one of the two. And I've always found that to be pretty good advice. And I think one of the things that experts, particularly when they're new and just getting started, is they underestimate the need to be a good communicator, and underestimate their role in the entire process to help the trial lawyer, tell the story that needs to be told.
So being an expert isn't enough. It's not enough to just really know your subject matter, but it's how you communicate it.
Yeah, that's exactly right. The best experts, of course, know what they're talking about, but B, they can communicate it, and they're likable.
Mm-hmm.
They're the kind of people I like. Always like to use the sort of the saying. Is this expert somebody I'd like to go to dinner with? Um, and it's not, and that's not just from a personality standpoint necessarily, but that likability and that desire to be likable and communicative and empathetic comes through in social relationships with me as the lawyer, and it shows to the jury that this person likes talking to other people and likes doing what they're doing,
Do you have any
and
tips?
that's critical.
Do you
So,
have any tips for experts to kind of work on that? So you may have somebody with an amazing niche who really is one of the premier experts in the field, but just kind of isn't the best communicator. Is that kind of a dead end, or is that something that can be improved?
that's an interesting question. Like a lot of things, it improves with practice,
Sure.
but I think part of it, um, an expert needs to be with people and needs to spend time talking to people, try and telling them, for example, what he or she does for a living. Try have an underwriter or an actuary try to explain what they do for a living, and work on it enough where somebody like me can understand it. The other thing is, I think a good expert cultivates being what I would call an interesting person. Um, and I don't mean that as sort of a trait, but I mean that in the sense of being out in the world more, knowing what's going on in the world, you know, watching movies, knowing what people are interested in, watching how people communicate over social media, see how they learn things. A good example of that is your something breaks in your house and you need to fix it, your toilet's stuck. Where do we all go these days? We go to YouTube, right, and watch
Sure.
videos.
Sure.
And so a good expert needs to understand that that's how people learn these days, and tailor what they're doing in a way that fits within that sort of expectation that people have, for better or worse, for example. But it is the world we live in. So good experts need to sort of cultivate that ability and trait.
Let's talk about confidentiality and privilege. When you are working with an expert, these might be new things for them. They may not understand quite what the attorney-client relationship is and what you're allowed to say to who and how and all of that. How do you get them, a certain level of
Right.
understanding with all of that in a way that, they don't get into trouble themselves or get you into trouble?
Yeah. Well, it's um, jurisdictions sort of vary in how they treat, and judges vary in how they treat communications between
Sure.
lawyer and expert. But I think it's the expert needs to understand the litigation process and how it works. And if they want to know what to say, how to say it, and how to communicate it, the first thing they need to know is how things work in the courtroom, how things work in depositions. Most of the time, a really good expert can avoid most of those privilege and kind of confidentiality traps by knowing how it works, kind of understanding the issues, and then structuring what they're doing in a way that they don't get into trouble. Now, having said that, it's a two-way street. Um,
Hmm.
Experts need to demand from the lawyers that they're working with them to tell us what it is we need to be doing. Tell us where the traps are. Tell us where the problems are. Make us understand how this is going to work. Tell us about the lawyer on the other side.
That's really
Um,
interesting. I've heard from more than a few experts exactly that the ones who have been doing it the longest and have been the most successful at it are the ones who have taken kind of a proactive approach to their experting
right.
and told the lawyers a little bit like that. So that's interesting to hear that that's also your experience, that they need to come to you and tell you what they know, and not just rely on the lawyers for everything.
Yeah. No, that's right. And they need to take time off when they're not engaged, and go to a courtroom and watch a trial, watch somebody testify,
Hmm.
and sort of get, the litigation process I'm not sure saying it's a litigation game is a good way to put it, but it is a game in the sense that there are rules
Sure.
and there are unwritten rules, right? And there's a feel. The best experts I know get that feel from what's going on, so they sort of know it. But again, lots of lawyers I've seen break down because they just leave it to the expert, and they don't sit down and have those conversations about expectations on both sides. And experts need to demand of their lawyers information. What does a lawyer expect? What does a lawyer want? And to me, that's the key is having those kind of communications and dialogues.
And that's all. And
back
that's
and
all
forth
part
with
of.
one another.
And that's all part of preparation, right?
Right.
What are your techniques? How do you prepare expert witnesses for, say, depositions, cross examinations, or even report writing for brand new expert witnesses? Do you like to do kind of mock cross? Do you like to just talk to them over Zoom? Do you take a varied approach depending on the case?
Both, and it's a varied approach depending on the case and depending on the expert. Um,
Okay.
I'll give you a good example. A good expert will be a team player with the lawyer. Now, obviously, a good expert is going to tell the truth, but a good expert is going to look for solutions. One of the best experts I ever had was a fire scientist, and there would be a problem in the case, and he would say, I have to admit this, but maybe we can approach it this way. And
Hmm.
he would try to come up with not a way around it, but a way to deal with it in a way that would be persuasive from our standpoint. Again, not always telling the truth. That's has to be it. But it's like everything else in life. You can either say there's problems and there's a problem and there's nothing we can do about it, or you can say there's a problem and let's look for a solution. So depending on the personality of the expert and depending on the facts of the case, I will do all those things. Now it is really wonderful when you have an expert that you don't have to do all those things that knows exactly what to do.
Sure.
Uh, but those experts are not born. That's for sure. They get there through experience, and that's a bit of a problem these days because we don't try as many cases as we did certainly when I was a younger lawyer. So experts don't have that ability to get into the courtroom, which means, you're basically training off depositions and reports more than you're training off and being able to see, okay, how's this going to play out in the courtroom? You can, as an expert, you can be deposed, you can give answers, but you really need, okay, if I say, having said this, how's that going to sound in the courtroom? How's it going to play out in front of a jury? And that's hard to do. And so I sometimes will, try to do sort of not a mock deposition, more than a mock cross examination or mock
Sure.
direct analysis. And you always get into, okay, is that going to be discoverable, and what's the harm? I used to have a partner that
I've
would
never
that
heard
would
that
say,
before. Can
yeah.
mock cross be discoverable? There's a law
Yeah,
journal article waiting to be written on that.
yeah. Well, it's juries these days, they expect that. I mean,
Sure.
they know. I mean, they know your expert's not going to go prepare in a vacuum, and they know the lawyer's going to talk to the expert. And so you get into trouble, I think, when you don't give the expert all the facts, when you try to hide the P from your expert, because juries can kind of sense if somebody's hiding the P, and that's not a good thing. So I've always tended to try to give more information to my expert rather than less, um, for that reason. But it's a balancing act that you always are doing
One
in that
one of
regard.
the one of the preparation kind of precepts, things that I've heard a lot is that experts are being coached to only say exactly the answer to the question asked and not divulge anything more. Is that also what you recommend?
That used to be the advice, because it used to be we tried more cases, and so in a deposition, you want to give less, not more information. But anymore, with the way things work now, with more cases being settled, with mediation being a more important touch point in the litigation, I tend to be a little bit more freer than that. And
Interesting.
typically there are things I want the expert to bring out in the deposition. Even if it's sort of not exactly asked, here's kind of what to bring out. It's sort of like you see these people that like politicians maybe, and or media representatives. They'll be in a question and answer, and they will be asked a question, and they may say, "Well, I don't know about that, but what I can tell you is." And it's what I can tell you is, and they have their points, and I always try to sit with an expert or any witness and say, okay, here are three key points. These are the three things that we really want to focus on. And every chance you get, you want to come back to those 3 points, those 3 anchors. So yeah, I'm a little more, particularly these days, a little more liberal with that, because I mean, what, 90% of the cases settle. So you're really sort of negotiating and getting ready for the settlement talks in the discovery, and you want to make your points, score your points.
I'm not going to hold you to any kind of numbers or anything like that, but is it really approaching the high 90s of percents of cases that are? And contrast that with how it used to be. Where would you say that we were 20, 30 years ago?
Oh, there's actually some statistics on that. I think, as of even 4 or 5 years, it was 60 to 70% cases settled. It's gone up significantly, to the point that, there are many people that are, myself included, there are many people that are concerned about how younger lawyers are going to get courtroom experience. The problem is it's just gotten so expensive. When I was a younger lawyer, I tried a lot of what I would call penny ante cases, because it wasn't so expensive in those days. Now it's any lawsuit's phenomenally expensive with e-discovery and experts and all those kinds of things. And so it's gotten, pretty expensive. So you don't see as many cases go to trial as perhaps you used to.
Is the job of an expert witness these days essentially report writing?
I wouldn't necessarily say that. That is certainly part of it. But it goes a little bit more than that. Experts have a role.
What's the main utility of an expert to an attorney these days, assuming that it probably won't go to trial?
Well, scoring the points during a deposition is certainly one. I've seen people bring experts to mediations. I've seen experts go to client meetings. I mean, when I was a younger lawyer, I had a partner, and my mentor, and I was, if only I could take this expert to this meeting with this group of clients. And he said, well, absolutely take your expert. And I said, well, yeah, but the expert's more knowledgeable than I am, and I'm going to look like a dumb lawyer. And he said, no. You will get the credit for how good your expert is. You picked him, right? And sure enough, that occurred. So, the expert needs to sort of be prepared for various roles, particularly in larger cases, because there are any number of things, mainly supporting the lawyer, even if the expert doesn't go to the client meeting, helping the lawyer kind of understand the case from a technical standpoint so that it can be presented to a client or to an insurance carrier, to the other side.
One of the interesting things that I've heard from interviewing a lot of experts is they think that one of the main ways to get more work is to perform well, and sometimes even the other side will have like their their deposition or their performance or their cross or even their report, and even though that they weren't on their side, they may hire them for a future action. As an
Right.
attorney, is that something that you look for? When you're hiring an expert, what are the main things that you're looking for? When you're deciding who to bring on, is that experience
Well,
important?
yeah, and I have had experts that it might have been their first case being an expert, but they grasp what's going on quickly. They're able to communicate things. They solve problems, all the things that we've kind of talked about. And yes, I've hired experts that have been used by the other side, not in the same kind of case, but in a sort of related case, which you as an expert, you have to always remember to be professional.
Sure.
And not sort of burn bridges and be a jerk to the other side, because you never know where it's going to come, and it's just not good. I mean, that those kind of experts, they don't come across very well at the end of the day. And so yeah, I mean, it's kinds of things I look for, the things that we talked about. I used to have an expert that I used quite often, and unfortunately he's since passed away. But we would have he was a engineer in a large firm, and we'd have meetings with some of the people that he worked with, and they would be reporting and developing opinions. And he always had this great question when somebody would one of the people who worked for him would say, well, this fire started or this coil got really hot, and he would say, well, what's the so what of that? Which is a really good question to ask yourself as an expert as you're writing a report. Well, what's the so what of that? Because it leads you to make yourself understandable and clear. And if what's the so what of that is there really is no so what, then forget it. It's not important. But
Sure.
I always thought that was just a great test. And I asked myself of that. When I write a blog article or something, now I may have a paragraph in there. I'll stop myself and I'll say, okay, what's the so what of that? Do I really need to have that in there?
It really drives it home better than what's the what. Like, what's the so what of that? Like, it really
Yeah,
communicates that really well.
right. Yeah,
Um,
it really does.
not to put you on the spot, do you have any stories, where an expert witness in some way was pivotal to a case or fundamentally changed the way that you think about things, or was in somehow prescient in your career?
Yeah, I was fortunate enough to work with a fella who is a fire scientist, as I mentioned before, and worked with him on several cases. And he really helped me understand how an expert can really benefit the lawyer and make the case uh, uh, more persuasive. He was very good at sort of understanding and grasping the stories that I was trying to tell, and kind of forcing me to tell those stories. And I remember that he we had a case, and one of the issues in the case was whether something had spontaneously combusted. And so he said, well, let me just see if that can happen. It's not an experiment necessarily. So he tried it, and it never it never worked. It never spontaneously combusted. We'd always kid each other, and every time I'd see him, maybe a couple of years later, and said, "Is that thing spontaneously combusted yet, or is it still waiting?" But it's instructive because it was a sense of humor, and you could see how he was problem solving that. If it didn't spontaneously combust, okay, that's no big deal. But if it did, that would be a really big deal.
Sure,
Because,
sure.
and it was just one of the theories, several theories that we were working from. And if it didn't work, it wouldn't have been any big deal if he had to say that he tried it. In fact, it would make him look good, right? Because he could
Right.
say, yes, I approached that theory and we tried it and it didn't work. So I don't think it's, in my opinion, that's not how the fire started. On the other hand, if it did work, he would say, both. So that's a good way of sort of, he was trying to solve the problem, look at it from both sides, and have something that no matter what would be helpful, however it turned out.
Sounds like this collaborative relationship really is part of what makes an excellent versus a merely good expert witness.
Yeah, I think that's exactly right. I have spent a lot of time with experts, not just working on the case, but just having fun, going out to dinner, and those sorts of things, because you learn things about it. And I've always thought of it as a team approach, between the lawyer and the expert, which again works both ways.
Sure. I'd like to pivot to ethics before we wrap up. I've spoken to some experts who felt that attorneys have tried to kind of compel them, either gently or overtly sometimes, to answer questions kind of in a particular manner, or otherwise color their testimony. How can attorneys simultaneously employ experts that will help their case while making sure not to like unduly influence their expert opinion as such?
Well, it's a tough question. I always kind of start with, this is my theory of the case, Mr. Expert and Mrs. Expert. Now you tell me how that fits the technical requirements. And clearly, if it doesn't fit, then why do it?
Sure.
You can't do it. In that regard, the advice I always give experts is, if you have to admit something in a deposition, admit it. Don't fight it. Don't spend your time fighting something that's not worth fighting over, or by fighting over it, you lose credibility. The most important thing for an expert is to be credible. I always like to sort of preach that to them. You can't be credible as an expert if you don't believe what you're saying, right?
Sure.
So if I try to influence, it's not only ethics, it's just sound litigation practice, right? If I try to get an expert to say something he or she doesn't really in their heart of hearts believe, it's going to come out. It'll come out either on cross-examination, or the jury's going to see it. That's just the way it is. So yeah, I want the expert to understand where I'm going, but I also want the expert to tell me if that you really don't need to go there. That's not a good place to go. Try another route. That one's not gonna work. But you can't try to force your expert to say something that you don't want it. But where people kind of get crossways with that is where, as I said before, the expert doesn't try to solve the problem or solve the bottleneck. The expert just merely says, well, I can't say that, or I can't do that, or that's not right. And without trying to say, I can't do that, I can't say that, but I can say this.
Right.
And so that's so, but in the former case where an expert doesn't try to do that helping, that makes the lawyer try to fill that gap in, and the lawyer is not the expert, so it typically leads to problems all the way around.
Sure, and I'm sure that on the flip side of the coin, you're looking at the other side to trip up in that fashion, so that you can impeach them on that, right?
Yeah, right. And that does lead to sort of another sort of issue, and that is experts need to be aware of what they said before. Right. Either publicly, in the media, in articles, in the courtroom. Almost all of that now you can learn. Our lives are pretty much open books, and it used to be that some of that stuff was hard to find. Now it's easy to find. So experts need to constantly be aware of what they've said before and how that might play into what they're doing, and be prepared to distinguish it or support it, or there are things that you said before that are helpful. Right? It's not always harmful. So they need to be aware of that, and they need to, as I alluded to before, they need to sort of understand how to use technology to help them in their testimony. And a lot of times lawyers won't have that. experts can't assume that the lawyer will be technologically proficient enough to suggest tools for the expert to use to help tell the story. So the experts need to be thinking about that. None of us can afford to hide from technology and what it can do anymore.
Right. That's a fact. Do you have any other last advice for attorneys using experts, in particular newer experts or expert witnesses themselves?
No, just be a problem solver. Like what you're doing, like people. Don't treat it as being an expert, a testifying expert, is something that you have to want to do. And it's like some lawyers aren't litigators. Nothing wrong with it. They just don't want to do that because it comes with some price. There's a price to it. And so, for an expert, I think if you want to be an expert who testifies, you have to understand what that means and be happy and embrace that role, because it's not like writing an academic paper. It's not like teaching a classroom. It is a little bit, but not quite the same. You need to understand exactly what you're getting into, and you have to want to do it, because if not, it'll show.
Sage advice. Thank you so much, Mr. Embry, for joining me here today. I
have enjoyed it very much. It's always good to talk about these things, and to all the experts out there, good luck. It's I love working with experts. I hope they liked working with me over the years. We did a lot of hard work, but we had some fun along the way too. So.
And thank you to our audience, of course, for joining us for another discussion at the Roundtable. Cheers.
Thank you for listening to our podcast, Discussions at Roundtable. Our show notes are available on our website, roundtablegroup.com. Subscribe today on Apple Podcasts or your favorite listening apps.